now that don't do background checks. So people with criminal records are sometimes illegally blocked from working, and we handle those discrimination complaints as well as clearing the records to begin with. We worked on policy issues in that area as well. The other large bucket of cases that we handle are what I would call more workplace justice issues, such as wage theft, which is underpayment of wages. We call it wage theft because it's easier, and it really is stealing your labor if you're not being paid for all of your time. Discrimination cases, sexual harassment, and in a lot of these cases, these kinds of workplace abuses tend to impact low-wage workers more, and certain categories of workers are more vulnerable to this kind of exploitation, particularly immigrant workers. So Rue had mentioned that we work a lot with immigrant workers at CLS, including undocumented workers. And so I guess I just wanted to talk briefly about why this is happening. I mean, it's not like it's new. I've been there for 20 years, but the situation of low-wage workers generally now, you could say, I don't know if everyone saw, I printed something out that's sitting on the coffee table in the lobby about the wages of workers. So real wages of low-wage workers in Pennsylvania are basically not keeping pace with inflation, and in the bottom half of the labor force has basically not seen a raise in the last year. None of the workers in the bottom half are seeing a raise. Some in the region are seeing a raise, but not in Pennsylvania. Part of the reason for that is that we haven't raised our minimum wage in Pennsylvania since 2008. 2009 is when the federal minimum wage went to $7.25, and it's been at $7.25 ever since. Before that, the state minimum wage was raised to $7.15. A year before that. So basically our minimum wage has been stuck at that level for a long time, and that means that the whole bottom of our economic scale has not come up like it has maybe in other states in the region. So the chart compares Pennsylvania to Delaware, DC, Maryland, New Jersey. So all of those have slightly higher minimum wages, and that serves to boost other wages at the bottom. But what's also happening is the fact that our union density is so low, and so there's not a lot of workplace organizing. The workers that we represent are in non-union jobs, and that's where the kinds of, it's not that discrimination doesn't happen in a unionized workplace, but there's somewhere for those workers to turn, and if someone isn't getting paid correctly, your union would figure that out fairly quickly. But it's in the non-union workplaces, the pizza shops all over South Philadelphia, the food processing plants that our clients get picked up in white vans and driven to New Jersey to do. These are all the places where they're paying minimum wage, and if they're cutting corners, then those workers have nowhere to turn because they're not unionized, right? So everyone knows, I think, the story of restrictions on union organizing, how it's been harder over the last few decades. And so there's fewer and fewer organizing campaigns happening, and there's fewer organized workers, and there's studies that show that the more union density, the higher wages are for all, not just in the unionized workplaces. So I just wanted to put in context what is going on, that the inequality and poverty of Philadelphia is partly due to the fact that people can't make it in a low-wage job and can't move up to the next job either. So we're here to kind of help people with the legal claims that they present with when they come to our office, but that's the bigger context for how we're seeing these folks. And in particular, the workers that are most vulnerable are workers that are basically purposefully hired by certain employers because they think that those workers won't complain, the undocumented workers, like I said, or other immigrant workers too. So we see the worst kinds of cases of, let's say, the kinds of things that happen because of great power imbalances. Sexual harassment is about power more so than about sex, and these things tend to happen in these low-wage workforces to a degree that's different than in other kinds of workplaces, so that our undocumented clients that are being exploited might actually be sexually assaulted and not just words used against them. So it's the levels of exploitation are just more extreme at the bottom, where employers believe that the worker has no power, and sometimes the workers believe that they don't have power. And our systems are set up in a way such that you actually have to complain about the sexual harassment to have a legal claim, and that very person feels disempowered, has no voice. How can they complain if they have no safety net, etc. So these are the kinds of things that we're up against. It's a really challenging but rewarding practice. Our clients are amazing. The clients that come forward to present claims that figure out who CLS is and come to us are just brave and amazing, and we do a lot of work counseling them, talking to them about risks before we go forward. We do some group representation. Wage theft tends to happen not just to one person at a workplace, but to a number of people at a workplace. Same thing really occasionally can happen with different kinds of discrimination claims. So I'm glad to talk about those more if people are interested. And then I think part 4 or 5 of your question was what policy issues are we working on?
Advocacy. What is advocacy?
So we can talk a little bit about. Together with ROC, we're working on a sexual harassment prevention project that's focused on restaurants. Restaurants are kind of like the microcosm of low-wage workplaces generally. They're uniformly not unionized, and they have huge power imbalances even within the workplace in terms of, who's in charge and how people are paid. And let me just say how glad I am that we have Sam here on the panel who's got direct experience and non-lawyer experience to share with folks. So we can talk more about that project if you guys want. In terms of reform agenda, right now there's regs that are pending at the Pennsylvania Department of Labor and Industry. If people want to submit comments, now's the time by next Wednesday to raise the salary threshold for people who don't get paid overtime because they're a salaried professional or exempt worker. So that's going on. You can submit those till next Wednesday. But generally, I would say what we're working on is raising the minimum wage. We're in support of the Fair Work Week ordinance. If people haven't heard about that, that's a city council proposal that Councilwoman Gim has on the table to give retail workers mostly more of a say about their schedules, because if your schedule is unknowable, then you can't go to school part-time, you can't arrange childcare. These are mostly women workers, mostly minority workers in Philadelphia. We worked on the sick leave ordinance and on the wage theft ordinance. We can talk more about those if people have questions. And we're also working on promoting the series of reforms at the state level for discrimination to improve people's rights to report, to extend the statute of limitations back, to give more resources to the Pennsylvania Human Relations Commission, and to improve the process for reporting, because again, that's just like a very difficult thing for people to do who are in trauma, to report the trauma that's happening to you within a very short deadline. I guess that's it for now. Oh, the salary history ordinance was another one that's currently being blocked in litigation. And so there's a number of initiatives, both on the city level and the state level and the federal level, that we get involved with. I mean, it's not really the moment to get pro-worker legislation passed necessarily in Harrisburg or in DC, but we fight defensive fights in those areas because there's usually like anti-immigrant legislation that's cropping up every couple of years in Harrisburg too. So is that an answer? That is an answer. Is that a good answer?
That's a lot. We are, it's amazing. It's, I'm always so impressed and amazed at all of the CLS attorneys who do this every single day. You can imagine how traumatic it is when people are coming into your office, the amount of, the burden on them, the losing the jobs, the evictions, the kids taken away, and how they have to stay strong and fight the fight to get through it. It's really amazing, and it takes a lot. So Sam, you're next. Nadia talked about a project she's working on with you. We're working on it too, and I'll, in the end, tell you a little bit about what we do as well. But tell us how ROC works to fight for fairness in the workplace, and what about the restaurant industry in particular makes it so challenging?
Absolutely. So I'd like to say, as a result of the current administration in Washington, D.C., and the extreme gerrymandered makeup of the legislature in Harrisburg, we are experiencing an unending barrage of assaults on the rights, security, dignity, and income of working people at this time. Now, more than ever, the Restaurant Opportunity Center, known as ROC, and other worker centers must forge an even stronger alliance with community legal services and other such agencies to secure justice in the workplace. We have worked together on a number of projects where we have had some success. Probably the primary one would be paid sick days legislation in Philadelphia. Paid sick days was actually a 6-year fight. It was first passed in City Council in 2011, vetoed by Mayor Nutter, passed again, vetoed again by Mayor Nutter, and passed a third time with the help of, again, CLS and our other partners, Women's Law Project and others. And as the outgoing mayor, Mayor Nutter, became suddenly a little more progressive and saw fit to sign the legislation. So as of May 13, 2015, we do have paid sick days in the city of Philadelphia. We worked to get that passed in other municipalities across the Commonwealth, Pittsburgh being the first, also some of the smaller cities. However, in Pennsylvania, we have a pretty ironclad preemption rule in the state. Preemption states that only cities of the first class can enact certain types of legislation, and wages would not be one. But cities of the first class are defined as cities with a population of 1 million or more, meaning only Philadelphia. So paid sick days is now being challenged in Pittsburgh through the Pennsylvania Restaurant and Lodging Association, which is part of the National Restaurant Association, which we refer to as the other NRA because of their anti-worker policies. Additionally, we worked together to draft wage theft legislation here in Philadelphia. Again, another area where we were able to do that in spite of preemption. We are allowed to do that. That was a collaboration between Community Legal Services, Temple University Scheller Institute, ROC, and several others. And the law students at Temple University, under the guidance of Professor Jennifer Lee, did the first comprehensive study of wage theft ever in the Commonwealth of Pennsylvania, and the finding was astonishing. They found that wage theft accounts for somewhere between $19 and $32 million in lost wages each and every week in Pennsylvania. You know, they're absolutely ridiculous. So obviously those sorts of things keep CLS and our other partners incredibly busy, and others on the panel, I'm sure, will be able to talk about a lot of those issues. Again, we worked very closely with Community Legal Services, Women's Law Project, the National Employment Law Project, to overturn the proposed DOL regulation coming out of the Trump administration that would have allowed employers to basically take and control tips. As most of you in this room are aware, the tip minimum wage in Pennsylvania is $2.83 an hour. It can be as low as $2.13 an hour, which it is in New Jersey. And the way that it's supposed to work is that if employees are not, if servers and tipped workers are not making full minimum wage counting their tips, then the employer is required to make up the difference. However, a study by the Federal Department of Labor in 2012 found that 84% of restaurants reporting were not in compliance. And that's those that reported. So that means that those that are actually doing this, I'm sure that number is much, much higher. The Trump administration proposed that these tips, which these workers absolutely need for bare survival, could be controlled by the owner of the restaurant. The owner could use them for capital improvements, could pocket them, could share them, could do whatever. There was tremendous support from Community Legal Services, NELP, Women's Law Project, and we're very fortunate here in Pennsylvania to have a progressive Attorney General. Attorney General Josh Shapiro contacted us and asked how he could help. He worked with us and several of our progressive restaurant partners here in Philadelphia and in Pittsburgh did press conferences denouncing this proposal. And as a result of the efforts of many, many people across this country, that proposal was scrapped, and it is finally codified into federal law that tips do belong to workers. So we are continuing to see these assaults. In Texas, over the last several weeks, we have learned that the Restaurant Association is challenging the 80-20 rule. There is a rule that says that tipped workers, that in order to get the tip credit, a company can only use that tip credit if tipped workers, or if 80% of their work involves direct work with the public where they are eligible to get tips. That would not include, cleaning the bathroom. That would not include prep work. That would not include a number of things that tipped workers are required to do. Well, now suddenly in Texas, the Restaurant Association and people of that ilk think that that regulation is burdensome on employers, and they should no longer have to keep track of that. So, going down that road, we could eventually see people classified as tipped workers who are in front of the public and eligible to earn tips maybe 10-20% of the time. So we have to be ever vigilant. I'm sure that we'll probably be working on some sort of preemptive work here in Philadelphia in particular, and hopefully in Pennsylvania as that goes forward. One of the things we're talking about with tipped work actually is something that has really been detrimental to workers in the restaurant industry. In Pennsylvania, there are over 220,000 tipped workers, 76% of whom work in the restaurant industry. These employers earn a sub-minimum wage of $2.83 an hour. To compensate, they must rely on tips that fluctuate based on season, shift, and scheduling practices. As a result, tipped restaurant workers earn a median income of just $11,563 per year in Pennsylvania, obviously below the poverty line, let alone trying to support a family. Our research has found that because of the tipped minimum wage, tipped workers experience sexual harassment at twice the rate of other workers, other low-wage and workers throughout all industries. The reason for this is twofold, we think. A, tipped workers making $2.83 an hour generally bring home a check of $0 because that $2.83 an hour goes to cover a portion of their tax, state and federal taxes, and there have been lawsuits that have where we have had tipped workers come to us 5 years, 10 years down the road working for an Applebee's or that type of restaurant, and they find that they owe city taxes, back taxes for 8 and 10 years because that tip minimum wage didn't even cover that. So a tipped worker bringing home a zero check feels that she or he has to put up with whatever the public says or does to them in order to get that tip. Additionally, in these tipped minimum wage states, they are also subject to the whims of management and owners. Managers and owners feel free to sexually harass their workers in order to pressure them into sexual favors or what have you, in order to get the better shifts or the better sections of the restaurant. There are 7 states in the U.S., in the West, that have never had a lower tip minimum wage, including red states like Montana, Alaska, and kind of, I guess, a purple state like Nevada. And those states have a full minimum wage for tipped workers. They report half the sexual harassment as states where there is a tipped minimum wage. So again, Nadia talked about our work with fair scheduling, and we've also been working on the state level on paid family medical leave, which would be kind of like unemployment insurance, where workers pay in a very minuscule amount of money per week into a fund, And if there was a catastrophic illness within the family, they would be allowed to have paid time off. So those are some of the things that we're working on, obviously in conjunction with CLS, working very, very closely with them, and we're going to need allies like that in order to get through, hopefully the next, 2.5 years, federally. Thank you.
Thank you. That's a lot of stuff, and I know you do not have a very large staff, so it is amazing that you guys do the work that you do. Miriam, you're next. How do you help your clients once they're in trouble, and what do they think they want, and what do they end up doing in response to your guidance as you represent them?
Well, definitely if a client is calling me when they're already in trouble, we're going to have a conversation about why I didn't hear from them earlier. But it is mostly the case, if that's when I first hear about a big issue, it's usually a client that I've worked with before. And just, I was actually listening to all of that. This is a lot of the information that you're giving, not specifically familiar with. I was trying to remember how many restaurants I've represented in over a decade. I think it's a total of 3. So it's definitely a different makeup of industry and in tipping in particular. Probably the closest analogy I would have is working with companies on their commission structures. But that is, a lot more defined usually. So I work with clients usually in the telecommunications and tech sectors. A lot of clients that I have that are continuous HR counseling and their litigation are more in the Fortune 100, Fortune 20 space, and they so their HR issues and when they have issues tend to be, from what I've seen, an issue more related to training and implementation rather than wholesale not having policies, not knowing what they're supposed to be doing anywhere in the HR machinery. But when you have companies that are spread out across the country, have different facilities, different management in offices with differing levels of autonomy, that's where I think the trouble usually happens. And so when I get a call that's, if they've already been sued for something, or if they know that something's coming, there's something flaring up with an employee or a group of employees, I think that's usually, what it turns out to be is a problem that's come about because well-articulated policies haven't made their way into full implementation or training by the people who have to implement those policies. The only times, the kind of clients that I have where they really are bound to be in trouble are startups that are moving into a space where they have more and more employees and they just haven't put in an actual dedicated HR professional. And there is there's a wide range of thought by people who start businesses on where they're going to concentrate their resources. There are now a number of HR consultants and vendors that you can outsource most of your HR work to. And so the question becomes, well, what are you doing about employee relations? And so things like benefit administration, third-party administration of benefits, payroll, all of that stuff can usually, for smaller shops and smaller employers and mid-sized employers, I think is usually a much better risk management measure to have that outsourced to a company that is designed to handle that and that keeps abreast of regulations in different municipalities at the state level, at the federal level, when they don't have a full complement of HR professionals to handle it internally. But you can't outsource employee relation issues. You can't outsource performance management issues. You can't outsource how you deal with your employees. And so when there's nothing when there's no attention paid to that until a workforce becomes bigger than all the people who are, together on the ground floor, is when we start to see problems really starting to flare up. And so it becomes a conversation of, you need to think about what kind of resources you're putting into training your management, training your supervisors, maybe having an HR consultant come in and doing an audit to see where your biggest areas of risk are, and when that starts to in the startup, in the venture capitalist sphere, it usually happens when they're going through a round of fundraising. And the investors want to see, what are you doing to manage your risk? What are what are your personnel practices like? And so what I do with clients when I think that they are, there are gaps in their policies or their implementation or training, is I try to identify what the risk is for them and to make the business case to them that it is worthwhile for more than just a humanistic perspective, because that doesn't always work with decision makers, to address these to address these issues before there are disputes. And that doesn't always work, but usually then, if there is a dispute that it's not just an economic spend issue, it's also an issue of when there's a problem in the workplace, it can be paralyzing in a workplace. It's morale, productivity, and it's incredibly stressful. And so at some point, there's a tipping point, even for employers who don't necessarily personally care about, don't necessarily, have that as their prime motivating factor. There's always a business reason. And that's where I'll actually bring in one ethical piece into this, is actually how I decided to be a management side attorney in the first place. Because it is certainly not what anyone who knew me before thought I was going to do. And we're going to talk some more later on about the things that have been issues for me. But the whole idea of whether to represent management or workers, if you're at a big firm, you're usually only representing management side. There's a positional decision that the senior management makes that clients do not want to have a firm that's taking positions that management may not agree with. So I've only ever represented management, and while sometimes I have not felt like that, that is immediately helping workers. I think what, I would describe myself as very pro-worker. And I think it is really important to have people who are pro-worker in HR and representing HR and giving advice to managers in HR, and to be trusted counsel in those spaces. And so ultimately, I felt like it was for me, because I had access to that and I had the opportunity to do it and I had those opportunities. I felt like it was my most ethical decision to stay in the management sector. And especially now, I think I did leave Reed Smith for a few years, and I came back in 2016, and I was at Lambda Legal while I was away. And part of the reason I came back to private practice is because of the change in the administration, and because I felt like right now I've seen through like the commitment that a lot of the corporations have made at the ABA to increase diversity and inclusion in the bar in general. There are a lot of there is a lot more motivation that I see in the corporate space that I feel like I know how to access immediately to increase protections for everyone on matters that I think are important. than I see any motivation in the federal government right now, anyway. And so there are, I think, a lot of ways to improve the lives, because we spend so much of our lives at work, of people by working very closely with HR management. And certainly, not every client is interested, but there's usually a way, especially with clients who have HR staff who are very committed to HR careers. Most of the HR professionals that I've worked with, as far as I can tell, actually do care about treating people well. And that has been, my privilege of being able to work for companies that I think hire usually very good HR people. And that's not true of everywhere. But where it is, there is a lot of ground to be made in the last couple of years, especially expanding the training. And training has always been something that's kind of, since I've been practicing, a very check the box. Did you watch the video? Did you page through every slide? And it doesn't instill values. And so a lot of our clients have these value statements, right? And they don't do training on those values. And so I started doing enhanced workplace training with a sociologist so we do workplace compliance and culture. And so for the companies and the employers who are interested in recruiting and retention, and interested, I think, overall in lowering their risk, but it's a longer term strategy, they have to invest more resources into training from the top down, because no one in middle management is going to give a crap about really changing their viewpoints and engaging in things like social positionality exercises, or seeing how, empathy is something that is actually, something that is useful for a workplace relationship, unless they see the people at the top doing it too. And so that's where I've been focusing kind of the newer part of my practice on, is a lot of the interest in how can we address the hashtag #MeToo culture, and looking at the statistics of the EEOC filings over the last 2 decades. The numbers don't really change, right? The numbers have been very like they don't really go down. They sometimes fluctuate a little bit, even in the last 2 years. And I think that's because it doesn't really represent how much harassment is happening in the world, and the workplace is part of the world. Because not everyone is going to go through that process. It's not a fun process. There's a lot of barriers to that process. And I don't think that the people who necessarily file charges are representative of the people experiencing the worst forms of harassment. So, ironically though, it's the only place in our society where people regularly undergo training. Otherwise, it's just the society we live in, which I don't think is very anti-harassment. So that's where I think we can make a big impact with employers, is looking at how to marry going beyond the minimum floor of compliance to a cultural shift.
That's a big and heavy lift. Thank you so much, Miriam. I neglected to do something in the beginning that Sarah had asked me to do, so I will start now before it's a little late, of getting a show of hands, I'm sorry, of who here, how many lawyers do we have in the room? Almost everyone. Who represents employers? Who represents employees? What do the rest of you do? Union. Who's involved in unions or represents unions? Labor?
Non-lawyers.
Non-lawyers. Well, and shout out to my Deputy Director Pam Gwaltney and our Boston Embrace Hurst in the back, and from the Commission on Human Relations. Anybody do discrimination work? Great, excellent. And we know we have immigrants' rights advocates here as well. Okay, so Sarah, How are your clients different or not from the people who India represents?
Okay. Hi, everyone. The employment group at Berger Montague focuses on wage and hour, class and collective actions. And in some senses, our clients are no different than India's. We represent low-wage workers in a variety of industries. We do it nationwide, which is a little different in terms of the geographic reach. And in some ways, we also represent employees who are higher wage workers but are still having their wages stolen by companies, and typically in those cases they're large companies who are smarter about the way they're stealing wages and have had a lawyer vet the way they can steal wages, and we try and attack that from a larger scale on a class and collective action basis. So we often find that industries get concentrated in terms of different types of wage theft that are being employed. So in the meat packing plants, we had a bunch of those cases where we represented meat packing workers, and they were all being paid on a gang time system where you would get paid from the time the piece of meat crossed your station to the time, but you would stop getting paid when the last piece of meat hit the first station. So you would have to continue processing your meat even though you were no longer getting paid for it. And we took on that industry along with a number of other attorneys at the time. They're probably screwing up again. There's no injunctive relief under the FLSA, but at least for that, once you start bringing those lawsuits on a class basis and making employers see that these are big problems that they have to deal with, they tend to change their practices going forward. Another example that we've seen a lot of that's happening is in the gig economy, where people are being classified as independent contractors, and the law on that is different by state. And so what we find is that big employers are outsourcing their certain type of their business. So for example, the delivery segment of their business. And so what they're doing is they're utilizing thinly capitalized third-party companies who don't necessarily have the resources to pay overtime and still make a profit, and the big company then funnels money to them, but not enough to pay overtime for the workers, and then gets to wipe their hands of any liability and just say, oh, sorry, this has nothing to do with us, even though these workers happen to be delivering our packages, catching our chickens, doing various things like that. And you've seen a rollback in terms of joint employer law, both for unionized workers recently with the recent changes to the NLRB, as well as in the FLSA context, which makes it more challenging for employees to recover their wages from the company they're actually doing the work for, who has the money and resources to pay, and they end up, you have the smaller company who just says, oh, sorry, we did that, but we don't have any money, we would go out of business if we paid it. So I think what we've seen are large-scale practices that are intended to evade the law through dealing with the fact that we have this patchwork law that was enacted in 1938 and maybe doesn't know how to deal with the gig economy, but you have these workers who are left in a situation fully unprotected with unemployment insurance, workers' comp, things like that, let alone getting their wages and overtime, having stuff taxed from them as their expenses. It brings down their wages altogether. And so we found that even in large companies, there are always business incentives to do the thing that is not helpful for your workers. And I think that you've seen a lot of tweets about the unemployment rate being at historical lows, and perhaps it is. I don't know who we can give credit to that for, but fine. But what you're also seeing is what Nadia talked about is really sluggish wage growth. And so people may be employed, they may be employed in 3 or 4 jobs, but they can't make enough money to live their lives and have their families without working 60, 80 hours a work week, which is precisely the opposite of what the FLSA was intended to do. We're sort of going over, so I do want to say briefly, though, that we are also dealing with an incredibly hostile Supreme Court and a judiciary system which does not necessarily recognize the realities of work and has taken really significant steps to undercut the only way that workers have to assert their rights, which is either it's collective effort of some sort. So they've undercut union activity through the Janus decision and a variety of other issues. So people, have a harder time unionizing and raising their wages in the way that Sam and Nadia talked about. And then you see a drastic attack on class and collective actions from all sides, but from the judiciary. And then on top of that, you have the Supreme Court's recent decision in Epic, which said that you can have class and collective action waivers in your mandatory arbitration agreements so that you can no longer, an entire employer can wipe out the ability of employees to bring a collective or class action by simply requiring that they sign an arbitration agreement, or in some contexts not even, requiring a signature. In the case I had in Texas, it went the wrong way, and having to arbitrate their claims. And so you can't even attack this policy that is obviously impacting people on a class basis. That is a policy that they're applying to all of their employees, and there's no recourse because the company may have to pay a little bit for, a couple of individual arbitrations, but not enough to counteract those savings that they're making by treating people and stealing their wages. It seems like now when you have your birth certificate, it'll say, I arbitrate every claim that I ever have. And
with my parents.
Exactly right. Forever, for the end of time. I guess we're waiving your rights to jury trial. So, it's not a pretty picture right now. I mean, it's not a pretty picture in a lot of different areas that a lot of us care about. But there is hope, and we can talk about some of the ways in a little bit that you can kind of work around that. And I do think it's important to remember that when FDR got the Fair Labor Standards Act passed in 1938, it was against the backdrop of a very, very hostile Supreme Court to begin with. And so his entire legislation that he came up with, through the FLSA, through other pieces, was against the backdrop of a Supreme Court that was invalidating laws that were helping to make people safer. So we, I think, as progressives, have relied on the Supreme Court as kind of a backstop, and maybe we need to shift our framework a little and figure out how to do some of the, vote, but also, figure out some ways to legislatively work things up and, rely on localities. And Philadelphia has an incredibly strong wage law that we can talk about. Our Attorney General has recently teamed up with the Massachusetts Attorney General and some other Attorney Generals to end a practice of franchises who have no poach agreements in their franchises, so that if you work at McDonald's as a manager, you can't get hired at another McDonald's, different franchise as a manager, even though they're arguing that they're not joint employers and totally separate and different franchises, so they're independent companies conspiring to suppress wages. Anyway, so our Attorney General is doing some great work on that, and I think Berger and Montague, I'll say this, so what's different? So get back to CLS. Right. All right, let me end with CLS. So Berger and Montague is different because we are a for-profit plaintiffs class action firm, which means that I have to make a budget and I have to make the firm money. It's part of what I do. And so one of the things that means is that there are lots of really righteous cases, like nail salon workers in Philadelphia who are treated like slaves, who it is not financially viable for me to take on. And I've been lucky enough to co-counsel certain cases with CLS. But what CLS provides is a really unique gap that people cannot get because people who work at smaller companies, at places where all of these practices are happening, it is often not viable for a firm like mine to take that case on. And CLS, to provide the level of representation that they are able to provide and the high quality representation that they are able to provide in that gap, is a critical service that we should all be incredibly grateful for. And one of the ways that you can support CLS if you are a class or collective action litigator on either side is through Cypre. And here are some ethics. cypre in Latin means as near as possible to the thing. And so what a cypre award is for non-class action and collective action litigators is that when you settle a case for your workers, or you're settling a case on behalf of the company, you deposit a certain amount of money as the gross settlement amount into the bank. Once the court approves it, checks go out to all your workers. If you are on the plaintiff's side, do not agree to reversionary settlements. They are a ethical trap that one should avoid. But if you're sending out checks to everyone, a certain amount of them are going to not be cashed for, people move. There's no way to get 100% of people to cash the checks, and so you're often left with some amount of money which can be significant as the part of the gross settlement. The Third Circuit in the in-re baby foods, baby products antitrust litigation has said that the designation of a cypre needs to have a direct benefit to the class. So in a case of workers, I often have management side lawyers saying, well, I want the cypre to be the American Cancer Society. And while the American Cancer Society is a great, great organization that does tremendous things, there's no direct benefit necessarily to my workers who are being screwed with their wages. But CLS is the most direct benefit anyone could ever imagine. They are the backstop and the backbone of our legal system in representing low-wage workers. Rock, I know this isn't a rock event, but they're also be good cypre. Let's give them a shout out to. Oh yeah. And so I think it's important if you're a plaintiff side lawyer to push back and don't. I've seen a lot of plaintiffs lawyers just say, oh, whoever the management side attorney wants as their cypre is fine, and if the court dings it, the court dings it. But I think it's important, and one way that you can be a good advocate is to really push for an organization like CLS or ROC or wherever geographic location you are in to be the designated cypre, because you are doing good and furthering the work that then they can do to help more workers.
That was fantastic, Sarah. Thank you so much. This comes as a surprise to anybody who signed up for this CLE, but there's a significant amount of Philadelphians who are one paycheck away from some other disaster happening in their lives. And the fact that these folks can help them and work with them in whatever way to keep their jobs, or also to give management good training and morals and resources to make sure that people can stay at their jobs is so important. When I was at CLS, I did housing work, and really, you miss a paycheck, you miss that rent payment, you miss that mortgage payment, the next thing falls off, and before you know it, you're homeless, you're moving your kids across the city, and you're taking them out of school and moving them in a new school. There's a lot that happens, and for low-wage workers who aren't even being paid enough, getting that ongoing income is the most important thing, even if they have to supplement with others. So we can't thank you guys enough for all that you do. I'm lucky enough to be able to work with so many of them. At the Commission on Human Relations, we enforce the anti-discrimination laws, mostly the Fair Practices Ordinance here in Philadelphia that says you can't discriminate against people in employment, housing, and places of public accommodation, and over 16 protected categories that include many categories that are not covered at the state and the federal level, like sexual orientation and gender identity. And we work every single day to enforce those laws and to make sure that people are feeling safe and protected at work and are also getting equal treatment. Do a lot of work with CLS on the Ban the Box law, which we officially are changing the name to the Fair Chance Hiring Law, because Ban the Box was too narrow. But the law is passed in Philadelphia that employers aren't allowed to ask about criminal records until they give a conditional offer of employment to the applicant. At that point, you can run the criminal background check, and you still have to, if you find something, you've got to do a 3-part weighing test of looking at what's the nature of the crime, when did it occur, and what's the connection to the job the person's applying for. And after all of that, even when you're looking at things like rehabilitation by the employee who maybe this incident happened, and also you're not allowed to look back further than 7 years absent times of incarceration. So after all of that and looking at elements of rehabilitation, even if then you don't want to hire somebody for the job because you feel like it is it's a risk and a threat to your business, you have to write them a letter and tell them in writing why they're not being hired and give them an opportunity in 10 days to respond so they can show you what they've done or why. I don't know, for some reasons, I remember from Lydia's cases, sometimes it was still the wrong person, it was never expunged, and various other things. But actually giving people an opportunity to say, you wanted me for my skills and qualifications, and now you're telling me I can't get the job for this bad act, and let's actually talk about what it is, so that's good. And we've been involved in so much of the litigation and the legislation, from the wage equity ordinance that still is being litigated to various unpaid leave laws and other things like that, we are so lucky that we get to partner with people at the table. And I will say, in my role at the commission, I love working with employers. I love working with employers who actually want to learn and do better. And you know, again, another shout out to my deputy in the back, Pam Gwaltney, who also you know, goes out and trains people on the Fair Practices Ordinance and various other things all the time. We have another deputy who does implicit bias training. We give them all the tools that they need in order to make sure, again, that they have a safe and equal workforce, and are constantly asking questions from them. When an employer calls me up, including the city of Philadelphia, saying, I have an employee here who is transitioning from male to female, tell me what to do. And we start having the conversation about training, about bathroom use, about pronouns, about what they should be talking to their staff about how they should be very supportive, and it's also okay to make mistakes occasionally and do your best. Also people who, you know, come to work one day as Christian and get into a relationship and 6 months later say I'm Muslim. And sometimes employers panic when that happens, and these are conversations that we have, and always good ones, and always, for the folks who are coming to us proactively, great. You had a complaint filed against you, and we had to order training, also good at the end of the day, but not so good for you. Anyway, I feel like it is a changing tide. We're in a bit of a bubble here in Philadelphia. We're also passing lots and lots and lots of great legislation, which is making Harrisburg very upset and mad. And one huge risk to everything that's happening in Philadelphia is more preemption laws. And we can't have that happen, and it's something for all of us to keep in mind of how we can make steps to protect people, and also make sure that, you know, don't poke the dragon, as I always say. Don't poke the dragon, or don't poke so hard that the dragon preempts you. So I say all this, I have some, that's a good one, huh? You're tweeting that then? Okay. With the time remaining, because I do want to get to questions, I'm going to start with Sarah, who has already talked about, I don't know if you have exhausted your ethical comments for today, but to make our way down and to just keep it kind of open-ended for anybody who wants to talk about some legal ethical issues. If you need some prompts, I've got some prompts for you, but I feel like you guys know what you want to tell this crowd.
So I guess to cover some more ethics briefly for those who are litigating class or collective FLSA settlements, and I'll keep it brief because it gets a little wonky and less fun than kind of the broad things that we've been talking about. The FLSA is interesting and unique in that one of the things that did get through Congress, despite all of the amendments, was a requirement that settlements must be approved by either the Department of Labor or a court. So you, unlike a sexual harassment claim or discrimination claim, you cannot do a confidential FLSA settlement. And the policy reason behind that was explicitly because if one worker is having their wages stolen from them, likely someone else is too, and the Congress, in their esteemed wisdom, wanted to make sure that those settlements were public so that other workers could take advantage of that if they saw that happening. So ethical issue number one is don't do a wage and hour FLSA settlement under seal. Sometimes you run up against issues where management side lawyers are insisting on confidentiality, and sometimes it's just a matter of educating them because they don't necessarily know they think that just a discrimination case or whatnot, and so there's some amount of education. There are also lots of circuits and courts that ignore that explicit rule, Texas and the Fifth Circuit being one of them. They feel like laws apply to them. And so in those cases, you can do it under seal, and so as a plaintiff's lawyer who wants to further make good law in the FLSA, how far do you push against that when it may jeopardize potentially your settlement in certain cases?
That's
So,
poking the dragon.
right, exactly right. And you want to do the right thing for your clients who you are currently representing, which is to get them the money that they are owed. So you struck sort of a balance where in jurisdictions where sometimes it's permissible and if the employer is insisting on it, you will not object to their motion to file it under seal. And if the court wants to grant it, the court can grant it. But what we will not do is agree to any confidentiality orders or gag orders against the individuals themselves. And that's sort of the ethical line that we have drawn. On that note, just briefly, one of the other nice things about the FLSA is that releases have to be narrowly drawn, so you can't do a general release. When you get an FLSA claim, you have to just release the claims alleged. So if someone has a sexual harassment claim, they can go forward, and just because you settled your FLSA claim does not in any way allow you to release those other claims. And then it prohibits things like no rehire clauses and some things that in the discrimination context I often find are sort of assumed that plaintiffs' lawyers will agree to. Once you reach the dollar value, they say, oh, okay, well now we're going to add on all these things that will never let the employee come back to work at this location, and confidentiality, and those things seem to be so pervasive in the industry. And I know Mary can talk a little bit about the tax implications of the Me Too movement and how some of that is shifting. But in the FLSA context, there is some protection there, and I think it's important for plaintiffs' lawyers to preserve that at all costs.
So there's so many ethical issues I could discuss, but what I think I'll start with is talking about group cases. So a lot of our cases are exactly what Sarah just mentioned. I mean, if you have a class case, there's a mechanism for settling and who decides how much you're going to settle for, because people who join the FLSA case have knowingly joined it and have put it in the hands of the lawyers in deciding. But we represent small groups of people who've been cheated out of their pay, or 2 workers who were fired after complaining about sexual harassment, or so 2 people at the EEOC, or 4 people in a municipal court wage case, or a state or a federal wage case. So what gets tricky when representing groups of people is deciding on how you're going to decide things, right? And so if someone is unionized, the union has that power in their hands, and so it's a group representation, but your client is a union. But when you're dealing with a few plaintiffs in a case together, it's tricky under the ethical rules to both diligently represent each individual, but also have an eye towards how is this case going to settle and how we're going to split those proceeds. So we've struggled with that at CLS in terms of figuring out whether we can put something into a retainer agreement about it, but that's also tricky to get our clients to think abstractly about what might happen in a few months if we settle the case and it's not for the full amount. How do you decide how to split those? So what we've done sometimes is have our I had a case recently where I told the clients, this is what's happening, you guys talk privately and you decide how to split it in a way that's fair. And we also advise people that they might want to get outside counsel, but realistically, our clients can't afford to go talk to outside counsel when there's some sort of ethical issue where the solution is go talk to outside counsel. Our clients just can't afford to do that. So we're a little bit stuck sometimes. We do the best that we can, and we are as transparent as we can, and sometimes we just tell our clients, you have to decide this and then tell me, because I can't tell you how to split this money. Sometimes there's ways that make sense, like if you know everyone lost X amount of dollars, then you can everyone can fairly easily agree to split whatever the proceeds are. Whatever you manage to collect, collection's another challenge for us sometimes, depending on the employer, but splitting it pro rata makes sense, except we had a case where one person, everyone was just working based on their recollections because they weren't getting pay stubs. So their recollections of what they earned, one guy recollected a lot more unpaid hours than others, and then when it was time to split the money, everyone was like, wait a minute, we didn't work that many hours. So these issues come up in group representation that are a little bit tricky and put us in a little bit of a bind, and luckily at CLS we have a ethics committee that we can talk to when we have issues. I would also say another issue that we face as CLS is a lot of pressure from judges to drop our attorney's fees in cases because they know that we are CLS and that we are providing free representation. So that's a challenge because of course attorney's fees is a big hammer and it finances us to be able to do other work. So we have clearly in our retainer agreements that even if we resolve a claim for a client, we still have, in the cases where we can seek attorney's fees, we will, and we will pursue those cases, and that the client has to understand that that's part of the representation, part of the deal. And we also sometimes have the executive director on standby if you know you're going to a settlement conference and you're going to get pressured to drop the fees or to cut them drastically. And so this is something that we face not just in the employment context, but in other contexts where we're litigating and feeling that kind of pressure to reach the settlement, right? And sometimes you do it because it is the only way to reach a settlement. Let's see. I can talk if people want to hear about. There's often positional conflicts within CLS because we do a variety of work. For instance, our elderly unit might represent people in nursing homes. And the employment unit is representing people who are trying to get a job in a nursing home despite an old criminal record. So we balance out the work we do by having internal discussions when there's a potential for positional conflicts that can come in with policy work or with litigation work. Firms deal with this all the time. I know that sometimes we look for partners to sue the state, and firms are always conflicted out because they have clients, the state is their client. So it's a different kind of thing, but we sometimes it might direct what we're actually asking for in Harrisburg, depending on the consensus we can get within units on policy work we're doing. And then finally, I guess I wanted to mention something about immigrant worker representation and the ethics. And so there's no ethical problem with representing someone who is undocumented. It's not an ongoing criminal issue. And in case people have never thought about those things, it's illegal entry or illegal overstatement of a visa. It's at this point at least, it's not a crime. It's a civil violation. So I guess some of the issues that can come up when representing immigrant workers, and again, I'm just blowing through these, so if people have questions when we get to the question part, please. Everything that we've talked about so far, we'd be glad to circle back to. We just want to quickly, fast talk through it. But I guess this happened recently in terms of, in this era of employers feeling more emboldened to threaten and retaliate our immigrant clients and tell them that they might report them. I just want to raise this because it actually happened to me in a settlement negotiation, that can be an ethical violation as well in terms of an employer raising an issue and solely for the purpose to embarrass, delay, or burden a third person. And so there are some ethical issues in terms of, if immigration status is not relevant to the case, and in wage cases it's certainly not relevant, it's been found to be not relevant under the FLSA, you can be paid for all of your hours no matter your immigration status, then raising it or asking questions in discovery could also be an ethical violation. And so we get those kinds of questions all the time, but I think we think about like just saying no and seeing what the judge will say, but it actually can be an ethical violation on the part of the lawyer for the other side. And I don't know whether the lawyers, if their clients are being completely truthful with them, because in my experience, employers are often hiring people knowing that they don't have status or looking the other way past seemingly false paperwork. It's when you get to litigation that they raise some of these issues to try to intimidate our clients from going forward. So I just wanted to raise that as well for people in the room that represent employers. We've seen employers themselves be more emboldened about threatening retaliation, but I'm clear that I just don't want the lawyers to go along that path. because it gives you a leg up in litigation. So that would be my ethics stuff. I don't know if you want to talk about ethics.
I don't.
No?
I've never had that issue come up. I always like to know when I can say, no, that's illegal. You can't do that. That is a very helpful thing to be able to say. But I want to mention 3 things, also kind of breeze through them. On the management side, well, anyone who does workplace investigations, the Upjohn case, the Upjohn warning is a big ethical consideration. So if you go in as a lawyer to do a company's internal workplace investigation, they can retain you and have it be start off anyway as a privileged investigation. And your relationship as an attorney is with the company and with the control group of the company. So you may be interviewing witnesses, employees who think that you're their lawyer or who are just not, don't know any of these implications at all. And so we do a routine Upjohn warning, it's called, and from a case in 81, and all the cases I'm mentioning, I think there's a copy of each of them, but I can also give you the sites if you're not familiar with them. And Upjohn dealt with a lot of privilege issues. Who has privilege as individual people in the company with the attorney representing the company. But it also dealt with an ethical section of the ABA rules, saying, okay, so if your relationship is with the company, how are you going to make it clear to people you're talking to that you're not their attorney? And so we have, I have a standard statement that I give, probably similar to anyone else's standard statement that they give. And it's, you say that I represent the company, not you. I'm doing this investigation, I've been retained by the company, and as part of that I need to gather information by talking with people, including people like you. And it's for the purpose of providing legal advice to the company. It means my conversation with you is protected by privilege, but that privilege belongs to the company. It's theirs, total discretion whether to waive it. We ask you to keep this conversation confidential to protect the integrity of the investigation itself, and also to protect the privilege, but understand that the company may make a decision to use the information and waive the privilege, and it will be their choice. And to make sure that they understand what you're saying before you go forward with the interview to deal with the ethical, but the potential that someone thinks you're representing them. And then the other couple things I wanted to mention are more about where I've experienced at least ethical questions in my mind of when I know that there are viable arguments for a client to use to either have a policy that or defend a case on the basis of an argument that I personally find sometimes reprehensible, but they exist in the law. And so I don't think as an attorney I can not advise my client that they exist. But fortunately I have, for the most part, had clients who, if they don't share my entire worldview, certainly maybe know me well enough to know I'm not going to make that argument for them. I will let them know that it exists, and that has been the case. This has really surrounded the evolution of the law around sexual orientation and gender identity discrimination outside of municipalities like Philadelphia and the Commonwealth, and in states where there are no explicit protections and where the courts have not, or at least the circuits have not found there to be protection, at least for sexual orientation under federal law. Right now, the state of the law in the Third Circuit is mixed. Third Circuit precedent is certainly still that there was a line drawn on sexual stereotyping being kind of the only theory under which someone could try to complain about discrimination on the basis of sexual orientation, as long as you can frame it in a way that it seems that there was some line drawn in 2009 and in many courts that actually being in a same-sex relationship or being attracted to people of the same sex, the state of being LGBTQ itself is different from any other kind of gender stereotyping. And that's been the fight that's been happening in the circuits. Pretty much every circuit prior to Obergefell came down on the side of how the Third Circuit has looked at it. Since Obergefell, several district courts across the country have found, and since the EEOC came out with a couple of opinions in 2015, finding that discriminating against someone because they are attracted to someone of the same sex is a form of gender discrimination itself. And so in Pennsylvania, the Western District, there was an opinion in 2016 that denied a motion to dismiss and found that Title VII does protect claims of sexual orientation discrimination. In the Eastern District, they went the other way in 2017. So currently, if I get a client who is not being sued under the Fair Practices Ordinance or a similar ordinance, I have to make them aware that there is this defense. But I also get to say, well, let me tell you a little something about what happened to Saks Fifth Avenue when they tried to make a similar defense. That there's just, it doesn't matter if you did this thing, and that's how it's going to be reported. So it's going to be, you can make the argument. It's a legal argument. I think eventually it's not going to work. I think very soon. I don't know how soon, but I make it clear that I don't think that you're going to have this argument to make for very long. I don't think it's correct, but it exists. And so that's where I've personally come down on the ethical issue. And then there's a related kind of issue with religious freedom versus sexual orientation discrimination, gender identity discrimination. There have been a couple cases in Pennsylvania and New York that I'm aware of where even before all of the Religious Freedom Restoration Act cases in the Supreme Court, people were fighting back against being disciplined for engaging in homophobic, transphobic conduct, and saying that their employers, requiring them to participate in training or to act in a way where they felt it was making some statement that they accept an LGBTQ lifestyle as okay, I guess. And disciplining them or firing them if they didn't, or for espousing what their religious views were if they were anti-LGBTQ, was inhibiting their religious freedom under Title VII, under the various laws. And currently, I think in Pennsylvania, or the cases that I've seen, have found that to be a viable claim. And the case that I saw that did go to trial, the plaintiff won, and this was someone who felt that she had been religiously discriminated against because she was not hired for a position, and the jury found based in part on her anti-LGBT stance, but she wasn't awarded any money. So I think that's the what happens when your sense of ethics don't necessarily comport with the issue, the arguments that you need to at least inform your client are available to them, and still make your recommendation.
Well, thank you all so much. Now we still have a few minutes left and wanted to open it up for questions if anyone has them. We've got these microphones at the end of each row, so pass it down if you want to ask a question.
So they're blinking red, and you turn them on, just press the button for a few seconds, and it should turn green, and then, like, this is not live, and release, and it's supposed to
ahead.
Are we on?
You have to ask a
Any
question,
questions?
Lisa.
I'm not a lawyer, I don't have questions. Okay, mine's on now. Okay. Who needs a live one?
While you're thinking about your questions, I just wanted to talk a little bit about the sexual harassment prevention project that Sam and Rue and I and others are working on. So our website is Safe Restaurants Philly. We are focusing on restaurants because they're the single biggest source of discrimination, sexual harassment complaints, way out of proportion to their size in the economy. And so what we've done is come up with a different kind of training that's focused more on prevention than on a liability training where you're checking off the boxes like Miriam was talking about. We talk about trauma, we talk about what might prevent someone from coming forward, we talk about bystander intervention and coworker support. So the kinds of things that will really encourage reporting because really employers need to know if it's happening because they need to know that it's happening so that they can stop it. But yet there's all these dynamics in the workplace that prevent people from coming forward. So I would urge you to check us out and hook us up with any restaurants that you know that might be in need of such a training. SafeRestaurantsPhilly.org. Any questions?
And direct us the funding too.
Yep, yes.
How did I do that? Just press this for a while?
Hold it for a couple of seconds and then.
Or you can just talk loud.
I can probably just talk loud. I'm Nicole. I am not a lawyer. I'm a labor and community organizer, and I am organizing domestic workers in Pennsylvania, starting in Philly. So wondering about litigation for low-wage workers that are excluded from the FLSA and work you've done around that or movement that you see forward on that.
That's a great question. Right, so domestic workers are currently excluded. There was some movement with the home health aides to get them coverage, and so I think a lot of that has to be political work that's done. Are they excluded from like a wage payment collection law as well? I don't think so, right? So you always, go
They're
ahead.
also excluded from workers' comp.
Domestic workers, right?
Yes.
That's so interesting. I think it has to be legislative. I mean, I guess you could invoke an unjust enrichment theory. That's worked.
I'll look up what that means.
It's so like you can have a contract that's written, and then the law says if you have a quasi contract that's like it's not fair, that's called unjust enrichment.
Okay.
That seems.
And I think, yeah.
Did I summarize unjust enrichment? Okay. It's like a quasi contract. So you can always
Okay.
bring a common law claim. That doesn't have to have any sort of statutory hook to it. I don't know, you'd have some problems because I guess you have like multiple employers, right?
Right, so for people who are private pay, working in an individual's home, house cleaning or nannying,
Right.
and don't have a written contract and aren't paid through the state or by an agency.
Then it's just that could be an unjust enrichment claim, right? It's like, or if there's a written contract, they could ask for a written contract. And in New York, Pennsylvania could pass this law. In New York, there's a law that individuals who, it doesn't matter whether they're employees or independent contractors, but if you're like a solo person working for a person, you have a separate claim and you have to have a written contract for any work that you do within a certain amount of time or the law is being broken. We could, I don't know,
Freelance is
Philadelphia
a
pass
free
something like
act.
that? Am I right about that?
Freelance
Yeah.
is free.
Right, that's right.
New York.
I feel like that could apply.
But I think you're right about the wage payment collection law, which in PA, they could either file a complaint with the Pennsylvania Department of Labor and Industry themselves, or there are attorney's fees available. I think it's, and then, also, that may face the problem of not having one large employer for an attorney to take it on. If you're not looking at a large amount of wages, it can be difficult to get a private attorney, but there are attorney's fees available, and there are liquidated damages available.
And I think the issue with domestic workers, we have a workers' comp expert in the back who might be able to speak to this, but the problem is, and any time that you're working for an individual homeowner, that there's usually not deep pockets, right? If the person's renting, you might not have a homeowner's policy to go against either for something that happens in the home. But I wonder if there's some other options. for instance, they're covered by the Fair Practice Ordinance as well. So if there's sexual harassment going on, they are covered. They are covered by the city's wage theft ordinance as well as the state wage payment and collection law. But it is a patchwork, unfortunately, for domestic workers who've been not covered by a variety of these laws over the years, unfortunately.
Could you develop, like, are you guys doing work where could you develop like a template contract? Because I feel like often domestic workers, like the problem is like a lack of information too, and like the household person isn't trying to do the wrong thing, they just don't know. But like, if you had resources like, here's a model contract that we think you should use, I could even see some people affirmatively agreeing to things that on the employer side that they, even if it's not mandated by law.
Or at least a template where people know what to ask for.
Right.
In terms of that. I think someone wants to speak to that.
I just wanted to clarify something that she said. She said that they're not covered by workers' comp, and I just wanted to say that, slight change in that, is that homes are not required to enroll in workers' comp, but some choose to do so, and in those cases, the domestic worker would be covered. So it's not that they're precluded from participation, it's up to the individual household. I just wanted to mention that because you might find there are people who aren't covered.
Who are good people.
They could negotiate for that. It's like obviously really unequal bargaining power though, right?
Hence organizing.
Yeah.
But
So I had a question, first, I think it probably most appropriate for Sam, on point of sale touchscreens. I've noticed that you see them a lot more often in more restaurants where you're not getting tableside service. Does that, I could see it being helpful in some ways for employees in that it documents the tips that are collected, but also being harmful because it gives the employer the opportunity to then treat them as tipped workers. I'm just curious if you have any insight on that, whether it's generally been more helpful or less helpful for employees.
Yeah, that's a good question. We haven't done the research to have an answer for you, but I think that it does offer protections for that particular worker, whether they're working counter service and the tip is automatically included. They would have a claim to that tip, I believe. And if it is, like the larger, your Applebee's or whatever, where it's right at the table, then you definitely have that protection and you can prove that those tips do belong to you as a server. I don't know if anybody else has an answer on the panel.
That sounds great. That's good. That sounds great.
Thank you.
Anybody else? No. Someone's dropping out. Thank you, everybody. Thank you so much.
I don't know if this is working or not. Thank you everyone so much for coming to this evening's CLE, to both the lawyers and the non-lawyers. I think we've learned quite a bit. Please join us for some refreshments in the hallway. Our panelists are available for further questions if you want to ask them one-on-one. Thank you again.
Thank you.
If you want CLE credit, complete this form that looks like this and give it to me. Thank you.